right. I don't want to wait too long because I want to give you both plenty of time. And folks, there is a Q&A section, and I see the first question has come in. So, Lenny, you can see the Q&A there, or do you need me
I
to?
can. I
Okay, you
can
can.
see it.
Great. All right. So we will take questions, I believe, at the midpoint and at the end, I think is the
Right.
plan, if I
And
remember.
I'm also going to be monitoring the questions as Alexis is sometimes discussing things so that if we know we're coming up to we're going to address your point, we will do that. I love the opening Q&A, Alexis. It was, should we wear patriotic outfits? And I would say that could backfire too. I would say be bland, be neutral, um,
Or be your normal self.
be your
This
normal
isn't
self, be your
time.
authentic self.
Be
Yeah,
your normal self that's not carrying an apple from the plane by accident, or you decided you had to have that plant, and put it in your suitcase.
right.
Don't do anything out of the normal, and be yourself and be prepared and actually be relaxed. There are eyes in the sky, and that
That's right.
something that can trigger it.
Yeah, just in case some of you are not aware, though, that federally we still regulate the active ingredient of marijuana. So be sure that your ointments and products that you're normally using inside of states that even might be sold at Walmart or Walgreens or whatever, if it doesn't have the exact amount of THC listed in it, you could have trouble with customs. All right, so Max, do you have your opening slide showing? Because I'm not seeing the
No,
slides.
not yet, but
Okay.
I will get that started. But first, I want to just thank everyone for attending our talk here. We're very excited at Immigrant to get started here. And I don't think Lenny Benson needs too much of an introduction, as I'm sure many of the people on this call have already heard of her before. But she's a professor at New York Law School, the founder of the Safe Passage Project, and a person who has been involved, who was an immigration attorney and is now a professor and has been involved in these topics for
40 years.
40
Yeah.
years. Yeah. Yeah. Just yeah. And is we're very excited to have her speak here. We've collaborated with her on other topics before. And I'm going to hand it over to you to introduce Alexis, and then
Great.
because I will start the slideshow.
So I'm very excited that Alexis Axelrad agreed to join us. Alexis is the managing partner of one of the most respected immigration firms in the country, Bars Muckmall. It's now called barslaw.com. When I first entered the field, there was no question at all that the founding partners of her firm were some of the first New York lawyers to really develop relationships with the old legacy INS, take leadership in AILA, and produce outstanding legal work. So Alexis is now the captain of that ship, and in addition is one of our national leaders in the American Immigration Lawyers Association, or AILA. And I've asked Alexis to specifically encourage all of you who are not members of AILA to join. And Alexis is going to talk about that in our opening here, because much of what we're talking about, how you navigate and understand rights at the border, secondary inspection, other aspects of customs and border protection issues, really helps when you have the community of AILA behind you. So Alexis, what else should we talk about there?
Well, Lenny, it's your fault that I got involved with ALO because I was Lenny's student in the fall of 1995 at New York Law School. And then she asked me to be a research assistant the following semester and sent me to my first ALO meeting in New York at the New York chapter. And then something like 12 years later, I was chair of the New York chapter. So it all starts from you. And ALO is incredibly important to me as a young lawyer. Yes, I landed at a firm 27 years ago that really supported ALA membership and participation, but I really learned how to be a lawyer every day at 26 Federal Plaza and talking to clients and everything I was asked to do, but also in the ALA community, and was mentored predominantly by women and then others, but by the old guard in New York City. And then, just taking it nationally. And it's been incredibly important to me, taught me how to speak in public, to really prepare. And, talking to your peers is different than when we're, selling ourselves to clients, and it really goes to the heart of ALA's mission, which is to elevate the practice of U.S. immigration law. So if it wasn't for you, I wouldn't be here.
Okay.
And take every opportunity to say.
Max, can you quickly do the next slide? And I just want to make more concrete to you why I'm encouraging ALA membership. If you have never been on ALA's websites, where you can post a query in the search tool and find the liaison minutes between Customs and Border Protection and the ALA committee. And that's where the founder of IARC, Camille Mackler, and Alexis Axelrad, they are famous, and Alexis in particular, for her many, many, many years of serving in that capacity of liaison between the bar and the federal government, and therefore has built, a lot of knowledge and understanding of the reality of the inspector's role, of CBP's role, and that's what we're talking about here today. Also, if you've never been an ALA member, you may not know that there's really active listservs. And while we have a wonderful one for the nonprofit world, sometimes I'm posting things in our listserv because I've read them in the New York Upstate ALA chapter, or in the Rome District chapter, which is the European International chapter. The Canadian ALA chapter is phenomenal, people. And so I'm just encouraging it again. And Alexis, you reminded me there's a discount if you're a nonprofit lawyer.
Yes.
Okay, let's go on to our next slide, Max. We're going to do a disclaimer because, just like all lawyers in the audience know, the facts matter. The status of your particular individual, their history, the things they said, which port of entry they're appearing at, it can really all vary. And so while we're offering our best information, we're not providing specific legal advice. Alexis, anything you want to add there?
Yeah, I mean, and also really something we're talking about within ALA, to be very careful with all your communications, and really think about when you're creating an attorney-client relationship with someone. It might feels easy to just give an answer via email, do this, don't do that, but to be careful about it, to think about it even more, and we're all taking a look at that. And insisting on a consultation is not necessarily, and of course in your world, is not necessarily to be paid, but it's to really understand what the relationship is there, not get yourself, not present yourself differently than you wish to.
That's a really good reminder for me, because since the new administration came in and there's been so much news, probably 3 to 4 times a day, I get this. I just have a little question. I just have a small question. Could you just answer this question? And I have not been doing that disclaimer often enough that I am not a practicing attorney for these people, and I'm trying to direct them to get information. All right, let's move on next. Next slide. Okay, this is going to be an active video of a real story. We'll just play a little bit of it because this particular news story really highlights why the current practices at the border have changed, well, they were always there, but now they're more rigorously being enforced, even for returning lawful permanent residents. So Max, can you hit the next slide and hit the go button? And usually there's going to be an ad, and we have to wait to skip past that. Whoops. Go back a slide. Yeah.
Okay.
Hopefully this is going to work. This is always one of those fun things.
Uh-oh.
Is
Oh, I
it,
think
it,
it changed in the conversion of it.
okay.
Give me 1 second.
Okay. Well, while you're doing that, many of you have heard of this story and other stories at the border, and Alexis and I both agree. In every news story we've seen, we've read between the lines, and we think there's a little bit more to the story. Whether it is someone who is at the end of their ESTA visit and is trying to renew it by going into Canada, or it's someone who has a O1 visa and their visa quote is canceled at the border, or whether it's an LPR who's being stopped in secondary and then put into immigration detention. And that's the video we were hoping to show if Max can do it. Okay,
Yes, I believe that's correct.
Max, I think if we
Uh,
can't do the video, let me just continue, okay?
okay.
And I'll just tell the story. This was a woman who was from the Philippines and had permanent residence for many, many years, but about 15 years ago was convicted of embezzlement. She was not sentenced.
Uh, Lenny, your voice just faded away
I'm sorry,
completely.
my dog just started barking. Let me close the door here. This is the joy of presenting from home. Sorry, everybody. Um, so she was a lawful permanent resident. She had traveled internationally before. She went to visit relatives in the Philippines. As she re-entered, her niece that she was traveling with waited hours and hours and eventually gets a phone call that she's in a detention center, not in the Seattle airport, but in Tacoma, Washington. What happened is that in her past, she had an embezzlement conviction. And if you look at 101A13, 8 USC 1101A13, it says that a returning lawful permanent resident is not subject to inspection unless, and one of those unless exceptions is if you have a conviction that could trigger removability under 237A2 or 212A2. And so in her case, there will be litigation about whether or not her particular conviction for embezzlement is a crime involving moral turpitude. And actually, I do teach this in my textbook. Embezzlement, depending on the divisibility of the statute, could be an aggravated felony if the loss to the party was more than $10,000. Both the crime involving moral turpitude or the embezzlement, which could be an aggravated felony, it's not a ground of inadmissibility, but it triggers 236 mandatory detention. So the very common question many of us are getting, I'm a lawful permanent resident, may I travel? I think the query you have to ask that person is, have you ever had any encounter with law enforcement? And I phrase it that way because people like to say, well, sure, I was arrested, but the charges was dropped, or I was arrested and convicted and it was expunged. Those things are still in your system almost always, not universally always, and they can trigger inspection. So Alexis, did you want to comment on the returning LPR with a conviction scenario?
Yeah, and as you said, not only a conviction, again, any touch with law enforcement. And it was even before this, frankly, I would hear from lawful permanent residents who were talked to on the way back if their name just came up in a law enforcement action, a family member, an associate. It feels very widespread now because of the media reports, which are a double-edged sword. The media reports are helpful in that it's warning people who, like you said, might have an expungement, and there is no such thing as an expungement for immigration purposes. It never goes away. It doesn't matter if they were a minor. It could be in that system, but it's reminding them, oh, I had something 20 years ago. Now I want to ask somebody about it. It's not your just lawful permanent resident traveling back and forth, really has no issues, really knows that there isn't anything. Almost every time an LPR has come to me and told me there's no reason they keep getting stopped, and I asked CBP about it, there actually is a reason. And sometimes they can tell me it's a national security hit. Sometimes they can tell me the exact reason. It really depends. But that media is doing a service by letting people know maybe I should ask the question. And frankly, I mean, I've been an immigration lawyer for 28 years, and I'm hearing from people I helped 28 years ago. So it's real. The panic and anxiety is real.
All right, so
Yeah.
Alexis, we're going to get more into the details. Let's give people the overview with this
Yeah.
slide right here.
But what is happening is it's in the system. If they're already left the United States and they're trying to return, it's in the advanced passenger system, and maybe they'll let them on the plane, and maybe they're not. If they let them on the plane, it's because they want CBP at the port to talk to them and figure out what's what. If they don't let them on the plane at all, we hear about that from LPRs. LPRs, again, as you said, are supposed to be admitted one way or another, entered and either sent to detention or admitted. And they will want to talk to them about anything that's in the system, even if someone has had a lost passport and it's in a stolen passport. That goes for US citizens. We hear that quite frequently. So that is why they need to speak to them.
All right, so let's talk we know that a lot of you in the audience are very expert in humanitarian relief and doing SIDGE cases and doing VAWA and doing asylum, but you have not been practicing in what we call legal immigration or NIV, non-immigrant visa immigration, as Alexis and I have. So Alexis, could you give us a picture of what is Customs and Border Protection? Our slide is wrong. It says Customs and Border Patrol. We already made a mistake. There's a
Yeah.
difference between Border Patrol and Customs Protection.
Wow, and I didn't catch that last
I
night.
didn't either. We were tired.
But actually it really works out to our advantage. So there really is a misnomer. I mean, Customs and Border Protection Directorate is the overreaching part of DHS. Border Patrol is within it, but they are very much separate. They have separate cultures, separate officers, separate leadership. Yes, the CBP commissioner, who will hopefully be approved tomorrow, I think it's tomorrow, Capitol Hill, well, they have, it's in that umbrella, but it's really, really different. So think of CBP, the people at JFK, at Newark, those officers, officers of Buffalo, Pearson, that's pre-flight inspection, Dublin, also pre-flight inspection, and think of Border Patrol working in connection at land ports. Think of San Ysidro, Tucson soft sector. CBP is there in some capacity, but that's really Border Patrol. And also think about Border Patrol's interior enforcement. Within, even 400 miles into Arizona, and there's a checkpoint.
That's right.
Think of Border Patrol in that way.
You should also think of Customs and Border Protection as having the customs function.
Oh, yeah.
So when in 2002, when we had the elimination of the old legacy INS and we had the creation of Department of Homeland Security, they merged Customs, which had been part of Treasury, into DHS. And there's still a little bit of an old mismatch of culture at the highest levels. In addition, they have their own national council, they have their own policy directorate, they have rulemaking authority. And if you're familiar with my favorite waiver, the waiver for non-immigrants who might be inadmissible, 212D3, they have a unit in Washington that are the attorneys who decide if a consular officer recommends that waiver, the adjudication of the 212D3. Um, Alexis, could you just talk a little bit more about uh, the structure of how policy comes down? Like, how do the port directors and those individual inspectors get their marching orders?
Well, I'll talk about what it is right now, because that's what's really driving a lot of this. The White House is directing CBP's Office of Field Operations. That's what's in DC, consider it headquarters. And between the executive orders, which, they have to interpret and they're trying to, it's being directed from there. There are no change in the laws. There's really no change in policy. There's change in programs that no longer exist, like CNV. I never say it right. CNHV, VH. You know what I mean? Parolees, Venezuelan TPS, although of course that's stopped by litigation right now. But it's coming from there, and that's where they're having to interpret what they want them to do in those executive orders and where you're seeing the differences. Now, the EO comes down, and sometimes with notice, sometimes with not. We're in the same position, very much like the Muslim ban. CBP was left unaware until it hit and had to handle all of that, and also COVID. And then they review it and see what they need to get out. They call them musters, to get out to the field. The field field office directors who are in charge of like in New York, the field office office is New York and New Jersey and all those ports. And then the port directors are the actual place, the port director of JFK, the port director of Newark. And the policies are coming top down.
As we go forward, we'll talk a little bit more because you gave us a beautiful picture of structure. Sometimes there's interaction also with ICRO, so we will be talking about that as we go through. Next, can we have the next slide? So a CBP inspector, I like that this person is so hip with their cutoff pants there. By the way, we want to give credit to Alexis's research assistant, Ralph David, who's a third year at New York Law School, who helped us with these slides and really pulled them together very quickly. So what is inspection? So we've talked about why LPRs or citizens are slightly different category, but why do people have to be inspected, and what is it that a CBP officer is asking?
Every single person, including US citizens that are returning to the United States, there is some touch before they get on the plane. If they're a land port, it's really happening right there in front of them. And if they get off a ship, it's happening at that point. But every single person entering the United States, and that CBP's charge is to admit them and to have an inspection. And that really includes US citizens. That's why, our issues about our phones for US citizens and US citizens attorney is so germane right now. So every single person, not only for their person, but also what they're carrying, as you mentioned, and of course the tariffs, which we're not going to talk about today, the tariffs come under CBP's purview as well. And I really want to say overarching what CBP's mission is to keep us safe. They'll start with that first, is the national security piece, and then they'll say facilitate travel to the United States, lawful travel. That includes US citizens, green card holders, those with visas, those who are visa exempt. And that is their mission. They want to facilitate travel. They want to make sure what's coming into our country is lawful. That includes people and the things that they're carrying with them or sending them.
So you helped me once arrange go on a tour with Ayla at the border, and that's when I learned about the money laundering dogs at the airports who can sniff out currency, as well as drugs. And it's amazing how every day at our ports there are people who have clothing filled with cash. Um, just to remember, CBP has an enormous job. If you've never read on their CBP website, A Day in the Life of CBP, they inspect more than 1 million people daily, cargo planes and vehicles crossing the border. So let's just be a little more specific, though. I think we could maybe go to the next slide, Max. Where do you get a visa? So we're talking now, let's put LPRs to a side for a minute. Someone is coming with an immigrant visa or a temporary visa. What's the difference between a visa and status?
A visa is, and I always think of it as a piece of paper, in this case, what's in their passport. If somebody doesn't need a visa, but otherwise needs to show how they can enter the United States, think of it as a piece of paper. You need a document to get you boarded. The airlines will get fined. They'll get fined for a lawful permanent resident, and they will get fined for somebody who's coming for mission to the United States if they have to turn them around. Not only do they have to pay to get them back on the plane, but they will get fined by the US government. So you need something that shows that you have permission to be here. It's just permission to get on that plane. It is CBP's job to inspect you when you get here to make sure that you are admissible to the United States. So those, and maybe this is the time to talk about ESTA, which is visa waiver. Or as you said, there are 41 countries that don't require a visitor's visa to enter the United States. They don't have to go to an embassy to get a visa. That's the only place you can get a visa, is at a US embassy outside of the United States. They've been approved for ESTA registration. The ESTA visa waiver used to just be called visa waiver. Now it's the ESTA process. Just put it all together. They're pre-registered, approved. That's what they show to the airline to get on the flight. But when they get off the flight, and CBP's had their information now, going digitally before they arrive, they still have to say what they plan to do here in the United States and for how long. Someone with a visitor's visa, that might be good for 10 years. Same thing, they are not going to be admitted to the United States for 10 years. At most, they'll be admitted for 6 months. And only if they have a good, they're plausible, makes sense, they look like the reason they're saying they're coming for 6 months. Same thing with somebody who's got a non-immigrant work visa that had to get pre-approved by USCIS, and they had to go to the embassy to get the visa that corresponds to it. So think about an H or an L. H-1B is, professional. L is a transfer from a foreign office here, or O for national and extraordinary ability. They're still showing themselves to CBP and have to answer basic questions about what they're doing here. And what people are really worried about now, where they had no problems before, I'm from Norway, was about to say Greenland, but coming from Greenland now might be a problem. I'm from Norway. They never talk to me. Why are they talking to me now? Again, that's coming from the White House. And if they have any wrinkle in their history, even one they didn't think was a wrinkle, that's why they're being talked to. But this is routine. This is very routine.
So I want to do an example that recently happened with an O1 DJ artist. She gets paid $15,000 to $30,000 a night for her extraordinary ability in running a music set. And she's Australian, landed from Australia to Seattle, where her visa was supposedly, quote, canceled. Um, she was very confused about this. They were in secondary with her manager. She had no understanding. She says, I have no reason why this would happen. And she chose to go on back to Europe with her manager. And so she left the United States. And then she was hiring an attorney, our friend Daniel Parisi, to try to figure out what happened. The first thing Daniel did was look at her social media. And her social media is really a lot about music and the drug scene. So it could very well be that that is an admission, although it's musical, of drug use. That's 212A2. Any use of a controlled substance is an admission of a crime involving a controlled substance. And therefore, the CBP said, we're not going to admit you. And of course, the manager kept saying, but we have an approved visa petition. We have a stamp from the consulate. You can't do this. Yes, they can. All right, let's do the next slide, Max. I think we're hitting some of these things about what is status. So as Alexis said, we call it sometimes also the dual check system. You have a stamp, she said a piece of paper, but it's actually a beautiful laminated machine tape thing in your passport so that it's supposed to be forensically difficult to copy. And then when you enter, CBP is supposed to put into the system an I-94 record. But they don't give those to people anymore, Alexis. How do they get that I-94 record?
It's actually amazing that it's online. It's so much easier for us attorneys to go on to USCIS's public, did I say USCIS? CBP's public system. And when I say public, not any person in the public can pull that I-94 record, the record of admission. You have to have the person's passport information and their birth date and other information to get it. But it's so much easier than the days of having clients fax you their I-94, they lost it or whatever it is, it's up there. And not only is their I-94 up there, but their whole travel history. So sometimes when the system doesn't work as it's designed and there's no I-94, you can't figure out when they were admitted to, the actual date they were admitted to. You can look at their travel history and then ask CBP to get that I-94 to you. So it's really important. They will still sometimes, some ports, write the admission date until they can stay. They don't always. And if you just go to Canada, if someone's here on a visitor's visa, they've been here 4 months and they go to Canada for 2 weeks and they think when they got back, they got another 6 months. They didn't. They got the balance. So it's really important not only to look to see what's on the passport, but to always look online, and get that I-94 and see if it's there or not.
So in this slide, we talk about 4 options where CBP can decide not to admit you and the choices they have. So one is they just refuse admission and tell you to go away on your own. They can detain you and actually put you in formal removal proceedings and charge you with being removable for being inadmissible. So that would be the burden on you under Section 212. If you are a returning lawful permanent resident, a case called Land of Presencia really says they should charge you as being deportable with the burden on them. They can allow something called deferred inspection, although I believe that's a lot rarer than it used to be, and they can allow you withdrawal. So for ESTA, just because we didn't put this in the slide, I think it's really important that people understand when you electronically register for visa waiver, you affirmatively waive all your rights. And this is under Section 217. And so if they refuse your admission, they could be potentially ordering you removed for 5 years. So, and you say, but wait, I get a hearing. Well, the only exceptions are a claim for asylum or marriage to a US citizen. And even that is tricky. If you have a visa and they refuse your admission, they are letting you go without giving you an expedited removal order, that's probably a withdrawal. Let's go to the next slide because I think I have this in more detail.
Yeah, and I just also want to say that detention is a misnomer. CBP is not detaining people, putting people in detention as you think about it for ICE or Border Patrol. Secondary inspection, primary is when you get off of the plane or your first line at a land port and you're talking to first line officer. That is called primary inspection. Secondary inspection will be in a room, in an office somewhere, deeper into that part of CBP at the port. Deferred inspection is getting, you're in secondary, they told you, okay, we need more of your documents. They can let you go. They'll give you a date to come back to show other things. But there really is no detention. Now, that it doesn't feel like much of a distinction when someone is separated from their family member, their US citizen family member, and they're brought into this room and it could take 5 hours, 10 hours. We're hearing more about longer, but it is not detention. And the ability to request withdrawal for admission, you can ask for it, but it's always CBP's discretion. And they have less discretion now with what we're talking about with people with old issues, current issues, that kind of thing. And I just want to say there's a lot of questions about traveling domestically and, who can travel or not. We're definitely going to get to those. We're going to answer your burning questions about that. That was really why I wanted to talk to you today and talk about rumor and an actual fact of what's going on. So don't worry, we'll get there.
Okay, so these questions are just typical questions we know that CBP inspectors are going to ask you, and of course, clients need to be told to answer truthfully. It doesn't help to answer falsely, and the case law is really harsh on 212A6C. A misrepresentation can be an omission of material fact. So let's go on, Max, the next slide. These are some things that CBP gets to look at. There's even more, but you may think, well, how will they know? This is what clients say. Well, how will they know? If they have time before a plane is landing or a cruise ship is disembarking, they have a manifest from the carrier. They can look at past admission records. Your passport is electronically readable and they can see every place it's been scanned into. They also, by the way, if you're a dual national, there's special rules that you should be very careful. If you're entering the United States, you must use your US passport to book your travel. Interpol federal criminal databases, there's the national security list, they're looking at social media, and there's money laundering watch lists, as well as the dog sniffers. Let's go to the next slide. Okay, Alexis was telling you there's primary and secondary. Do you want to refine that a little bit more? Are they the same personnel that work both stations?
No, primary is really just the person, the OC first. And even if you use global entry, but you get an X, more than an X, and then someone's waiting for you there. And secondary inspection is again further in to the facility wherever you are, think of JFK, think of up at Buffalo. And I want to really, you all should know there is audio and video at primary and secondary inspection. They keep it for about 30 days. So if you have a bad interaction or you hear of a client and they've told you about a not good interaction and you trust what they're saying, got to do some of fact finding too. It's really best to bring it up as soon as possible to CBP, and we'll talk about those channels because they can look at it. And I have in the past been on email chains back where they have admitted that was a less than optimal interaction. When my client told me she cried and they said some stuff. So they will, and they'll take remedial action there. But really to know that it is video and audio taped, but doesn't kept forever.
So the burning question everyone has is, when my clients put into secondary inspection, do they have a right to counsel in that secondary?
Not have counsel with you. They really can't have anyone in there unless they're not going to separate, very young children who happen to be US citizens with their parent or whatever it is. You can call deferred inspection. They can reach out to you. They don't necessarily take their phones or not, and a lot of times they're waiting for a long time. The thing is, and I get asked this a lot because of all my work with CBP, what can I do? Can I put you on retainer? Can I call you in the middle of the night? if they've made a decision about someone, there's very little I can do about it unless it's incredibly just completely off the mark. And all of that, you certainly can call, and those numbers are on the website. I also have a point of contact for you, not necessarily in the minute that it's happening, but if you really have egregious, situations that you want to let New York and New Jersey, the field office know about. But you're not gonna, we were kicked out of secondary inspection long ago, and deferred is their choice. So, you can call, you can email. I certainly email. And with a G28, very important to have your notice of appearance of attorney. There are some ways to get through, but it's really a process. Secondary is not always bad, and they just need the time to really look at something. I'll tell you a very simple way of this. Blanket L1s, that's a visa. They have an approval notice by the embassy. I had clients who are constantly coming through Newark, from one client who always packed their approval notice, not just their visa. They need to show their approval notice. They always put in their checked baggage. So they were always getting pulled into secondary on Sundays. And they had to understand they have to show both. Sometimes they don't get asked for both, but they have to show it. So again, being prepared, having all your documents, not in checked baggage. And if you know you have an issue, you don't have to jump up and down a primary and say, please, please, please talk to me. But absolutely don't. Clients should not have things on their phone to show CBP. You do not show CBP your phone voluntarily. Oh, here's my approval notice. And then you get a text like, hey, are you bringing the Molly to the rave tonight? That actually happened to a student years ago that I ended up getting involved with. So you want to be prepared for what you're trying to present. Have your paperwork there. And that actually goes to one of the questions. If you are pending I-751, remove the conditions on your residence. You've also applied for naturalization. You have no law enforcement touch at all. No, just even taken in for a minute. Just carry your 751 receipt notice with you. You can have your N400 receipt notice. You don't really need it, and be prepared to show it. And be able to explain what's going on with your case at the moment. I'm not
Yeah,
worried about your traveling.
I would say, though, you have to remember that when you do have your citizenship interview, you have to disclose that additional travel because that was part of the N400
Yeah,
process.
absolutely.
And you might get asked, well, why did you travel? Which might lead another inquiry. So,
Only if you went to a very interesting place. This is
yeah.
not the time to go to interesting places.
Not a time to go to interesting places, right?
No.
So I just want to talk about deferred inspection one more moment. Alexis would know whether they ever do it anymore. Back in my day in Phoenix, we often could do it. There was a more trusting kind of relationship. So I would train my clients to say, look, my lawyer has all the information. I'm an intercompany transferee. She'll bring all the documents, anything you would like. We're happy to come. Could we resolve this when I arrive in Phoenix? Could we do this when I get to LA? Could we do this when I get to Chicago? Very politely. And what you'd find out if you ever went to a CBP deferred inspection is lawyers are not allowed to speak. So you prep the client, and only if the officer directed a question to us were we able to say anything. So maybe you're familiar with that, team. When you go to an asylum interview, you're not supposed to be the one testifying or answering questions. Sometimes you can talk to the officer and say, could I add this? What do you think, Alexis, about deferred inspection? Ever happen anymore?
Sure, yes, but I, also know that the same way we are stressed and trying to deal with what's happening, CBP is too. I just heard from leadership last week in DC, both in a liaison meeting and then our spring conference for ALA, that they're reacting to this as well, and they absolutely don't want their officers taking what's in the media, right? The visa ban countries were published in the New York Times. And all of a sudden, you started hearing about CBP officers saying, well, oh, it's visa ban, but it's not. So there still is deferred. They are also dealing with the massive information, what's real or not. What's taking longer sometimes in secondary is them confirming something isn't true, something hasn't changed in the hour on Truth Social. They're in the same, it doesn't feel like it. We're in the same boat or the same side, but many times we are. And in this period of chaos, purposeful chaos and anxiety, that's also what's taking so long. But, deferred is still used, but you got to bear with them with the amount of volume and people they're talking to more these days.
Let's talk about social media in the next slide really quickly. We've already touched on it. Can you refuse to give them your phone?
You can, but well, you've not refused to give your phone. You can refuse to give your passwords, and then they will take your phone, and then can send it away.
But you should get a receipt for that.
Yes,
Right?
absolutely. And there's a very established process to how this goes. If you're an attorney, though, you should say right away, start attorney-client privilege. There's a different process for that. They get a lot of guidance on what they can do and cannot do.
What if you were a psychiatrist or a social worker? Can you also claim privilege?
I didn't actually ask them about, but I would, and I can find that out. I gather you could. There's privilege, but we were really talking about it for attorneys, and like I said at the beginning, I travel constantly. I'm going to Mexico for an ALA chapter conference, and I'm thinking about what apps I may want to take off my homepage. I traveled my whole life with this, which is probably not great anyway, and just thinking more about it. Again, my social media is about dogs and food,
Mine's
and
about dogs and bread.
right.
Yeah.
But the other piece of this, which people are asking about, is is it just law enforcement touch, right? There are very, very high publicized cases about LPR, from Colombia and political speech, and all of that. So I'm getting calls from a lot of professors who are green card holders and even U.S. citizens who are worried about their freedom of speech, their political speech on their social media, and whether they can return to the United States, even U.S. citizens.
Yes, although in the
Yeah.
1960s, the Supreme Court did say that the government cannot exclude Paul Robeson, the famous singer, for his activities on behalf of the Communist Party. But that doesn't mean they won't, this particular administration wants to revisit very old moribund laws, and some of those laws are still in the books. So a la the alien registration that's coming live in a few days if it's not enjoined. And there are rules about citizens as well, but let's hope that we don't get to that point. Okay, Max, next slide. So I think we've covered some of this, but I want to talk about expedited removal. Expedited removal is something that lots of lawyers don't know much about. This particular community of the immigrant art community, you're used to seeing it when you're interviewing a client and mom or dad, the whole family got an expedited removal, maybe at the southwest border, and you're trying to do a motion to reopen, you're hoping the 10 years have gone by so that you can help the client, or you're looking for relief like asylum or SIJ or T status or U status that might overcome a prior expedited removal. And I think everyone here also knows that there's something called reinstatement of removal. So if you have an old expedited removal and you're in the interior, you can have a reinstatement, and that's where individuals might have to meet a higher standard to seek that exception under the Convention Against Torture or withholding or a reasonable fear of persecution. What we're talking about that I've seen on the listservs don't understand is even when you have a valid visa stamp and an underlying visa petition, like an H1 or an O or an F, you can be put in expedited removal. And the way the CBP does that, or a B1, you're traveling as a tourist, business visitor, or you're traveling as a tourist B2, they don't use it for ESTA because you've already waived your rights. So it's Section 217, 5-year ban. Expedited removal 235B also results in a 5-year ban, but if the ground that they're saying you were inadmissible under was fraud, 212A to A6C, that is a lifetime ban. So it's a misnomer to think that you have your expedited removal only for 5 years. Anytime you apply for a new visa to re-enter the United States, that finding of inadmissibility on fraud needs to be overcome. Now, that could be a 212I waiver if you qualify. You could try for a 212D3 waiver. I know I'm talking in INA terms. That's welcome to my world. My students get this all the time. What I'm saying is that there is power even for people with visas at the border to be put into expedited removal. So what do? They look at your visa and it's an F1, and they say to you, are you working? And you say, yes, I work on campus in the lab. can we go back, Max? They should know that you're allowed to work 20 hours a week on campus in the lab. But if an officer made a mistake and thinks, oh, you lied about your intention to work when you applied for that F visa, they may write you up for expedited removal on 212A6C, or they say you have the wrong document. So 212A7, which also means lacking a document, that you have no documents or false documents. So people are, it's not as common, but people are issued expedited removals at ports of entry, at airports, at cruise ships. And AILA lawyers are really good, at least in the past, of getting that entire Q&A record, getting the evidence together, and helping the port director make a decision about rescission, because there's no judicial review. Years ago, Margaret Stock, one of the best lawyers in the country, tried to litigate this before the Ninth Circuit for a Chinese national who was coming to attend a trade conference. The government said she was really intended to work because there was an approved H1 in the record. She said, I didn't want that H1. The only way she even got to the court was she then asked for asylum. She didn't want asylum. She just wanted to go to the trade conference. Margaret represented her. The Ninth Circuit said Congress has court strip jurisdiction. In 2020, the Supreme Court, in a case involving a man who was from Sri Lanka and was only about 200 yards into the interior when CBP stopped him, did not pass his credible fear interview. Initially, the ACLU was successful in using habeas to say it was insufficient process to allow him to articulate his claim. The Supreme Court struck it down viciously, saying he had a full and fair hearing, which is ridiculous. I'm sorry, this is totally wrong. But sometimes the Supreme Court, not knowing the reality of what happens in these inspections or in these credible fear interviews, they have closed the door on habeas review of expedited removal. Alexis, have you been able to overturn an erroneous expedited removal asking rescission from a port director?
Yes and no. I've helped people get in touch with field office directors, or actually ask New York when it can to step into things that have happened other places. I really try to eliminate that happening for me, for my clients, where they're going, either telling them not to come or not to leave in the first place, or preparing them and preparing the field office in advance to let them know there's something interesting there. The problem is, and again, we should really explain, there's the CBP Office of Field Operations in DC. There's ports. Ports have a lot of autonomy. Well, they had a lot more before. They have less now because of the White House. And that's what's causing, again, people to be held way longer than they used to be. But the field office director could parole someone in, make decisions. So there are other ports that, there's some ports that are better than others. Frankly, I don't mind saying here that Pearson, which is pre-flight inspection in Toronto, is a place I don't send clients if I can help it. Very difficult there. Detroit.
I had a friend expedited removed in Houston, and you were telling me it was maybe to be
Houston's not
expected.
great either. Also, LAX, there's another reason for AILA is, besides, nationally, the local chapters and the local liaisons, and those listeners will tell you, we really rely very much also on the Canada chapter for really granular information about what is happening at, any place, especially if, you have a lot of clients that are going to come through there. It's really, really invaluable. And in the nonprofit sphere, really invaluable for that information. But if it's gone so far with another port, there's only so much the port director in another place can do. They can urge. I'll give you an example out of Dulles, which is where I'm flying back to next Sunday. So Lenni, bail money.
Yeah.
If I potentially need it, and my family lives right there. She was on a B2 cohabitating partner of someone who was on an L. So not just a regular visitor, but they were just unmarried. It was very clear you should not be working in that status. You cannot work. And they were not familiar with B2 cohabitating partners. They brought her into secondary. She's only 21, German. And they looked at her phone and they saw that she was babysitting and taking money for her neighbors for that. That is work.
That is work.
I tried, and I tried to get New York to get Dulles to rescind it, but it had already gone so far. So instead, they ended up getting married. She applied for an L2 visa. It was, the visa would have been approved, but it needed, was expedited removed. She had 5-year bar ban, needed a waiver, and the Admissibility Review Office, which is part of CBP, did not approve it. That was all my
Yeah.
fault, by the way. So,
And
it's
those
hard.
waivers can take 11 months now, is what I
Yeah.
understand, because they're very
It's
understaffed.
hard, it's not impossible, really egregious claims, yes, that doesn't mean you shouldn't try. And actually, Max, this is the perfect time. I would put in the professional service manager link to CBP's website. Again, CBP always wants our clients and us to talk to supervisors right away. But just like all of us, I just got into a fight at the DMV last week. And you're nervous, you want to get out of there, they don't want to talk to them longer, so maybe they're not going to ask for a supervisor. What if they didn't get a copy of their sworn statement? If you're talking to someone who is expedited removed, had any interaction, you want to ask for the document CBP gave them. I've never met a sworn statement I thought was good. They always say and do things that are like, oh my God. And then one of the questions was like, should they say immediately, I'm registered for medical marijuana? No, you should not. It's illegal federally, so no, I wouldn't say that. So then you can call deferred. If you don't get anywhere, you can call the professional service managers. Those are the CBP officers at every port trained who've asked for this position to problem solve. They can get you that document. They can see what's going on, get you more information. And then Max, you can put in the traveler redress inquiry program system. If someone is getting stopped, they're eventually let in, but they're stopped like 5 times, 5 times. They're told they have the similar name as somebody who they're looking for, or they lost their passport and it's in the system. You can put in a trip request and ask. They can put it in, you can put it in for them, and you can ask them, you say what the issue is, and it can potentially pull them out of the system. If it's low level, it's not an issue. And it could stay out of the system for a while because it refreshes and then maybe it'll happen again. So there are channels, and every trip request goes to headquarters. They review it and it goes to the port, and the port has to answer for whatever the request was about, and what happened, and it can turn into a training issue and fix something. So those are 2 ways. You don't need special access for that. That's access for everybody.
This is also useful, Alexis. I'm seeing lots of good questions. I hope we're going to keep working on them, go a little bit faster. Can we do the next slide, Max? This is the one you're all asking, right to representation inspections. I think we already touched on it. So lawyers are asking in the Q&A as well, if I can't be with the client, can I do a letter? So example, if my client does have a conviction, but it doesn't make them inadmissible, can I present information so the client has a packet? Can the client assert the Fifth Amendment? Can the client say, please talk to Alexis, she's my attorney? What do you recommend, Alexis, if someone is in secondary?
Okay, so yeah, I would prepare them. I would do a call, Team, Zoom, whatever it is, always better on video. If you can't do a call, prep them. You can prepare them with a package, but if they just want to hand it over and not explain what happened to them, they're going to say, I don't want to hear what your lawyer has to say. I want to hear what you have to say, very much like a visa interview when they're handing over the materials. It's all about the interview. So, and I know we're dealing with all different populations who might be more articulate or not, even in their native language, but have a hard time expressing themselves. Make sure they have the disposition of arrest. Make sure that they have the proof they weren't even charged. Yes, you can write something up, but don't have them rely on it. They need to be as familiar with that as you are. Not legal arguments necessarily, but just get out the main things. I was arrested, but then all the charges were dropped. Don't admit to what the charges were dropped for. Okay, be prepared. And some ports, yes, and especially at a land port, they might have time to look at it more, maybe not. Pre-flight inspection, if you're really worried about someone, don't send them to Pearson, never. But if someone's coming from Europe, they can go to Dublin pre-flight inspection. They can have it all there. And while I wanted to say you can still get ER'd. You are on US soil, even though you feel like you're in Dublin at the airport, but you are on US soil at CBP. But more likely than not, they're going to let you go, and you're going to go up the mirrored elevator. I've been in it not for me on a tour, that you're not going to come in that day. So if you're worried about it, you want to plan where they're going to have that interaction.
So
compare
basically,
them.
though, we don't get to be with the client on the phone with
No.
the inspector.
Not necessarily, no, not with them. You can try to call in. I mean, it's really just, something that's making no sense. They absolutely have it wrong. Or frankly, your client has a medical issue, or, there is a problem with their, developmental, really try to plan for them to travel with someone who's with them if you can, someone who's very elderly, of course, someone who's very young. I'm not talking about unaccompanied minors, but just like whatever the situation is, try to make sure that there is someone there, and you can try, but your client has to be prepared to be able to talk about it. Or don't go. Don't travel. It's a terrible thing to say don't travel now. People talk about I-751s, that's that viral TikTok where she wasn't admitted back. There was much more going on in that case. They weren't canceling people who just have pending 751s who have nothing else going on. There's another question about if it's being out for 180 days triggers these top people talking to it. The triggering event is any touch with law enforcement, even if it's long ago and went away. If there is an NTA, yeah, you're renewing your application for permanent residence removal proceedings. You have a paper on 94 that says you're still a permanent resident. If you have an NTA, you're going to be detained on the way back. That's a change. That's a change in discretion that they no longer have at a port that's coming from on top. Do not travel.
Yeah, I would say anyone that has an NTA, if they travel, they may have also just triggered
Right.
removal. So one more thing about this issue of 180 days, permanent residents, there's a myth. They think as long as they enter every 6 months, they are maintaining their permanent residence. No, it's a mental state. So your objective behavior must demonstrate your retention of your residence here. And I've read a lot of the old cases and I've had clients and I know people. They really do target elderly Asian people who got green cards because their children immigrated here and they just want to be able to go back and forth and spend months at a time. If you are not filing your taxes in the US as a resident, that is an most obvious abandonment of your idea that you are a resident. US has worldwide taxation for permanent residents, and then it's based on country-specific treaties. If you had to leave to attend a graduate program or medical care for an elderly person, there is a way to get a reentry permit to preserve your permanent residence. But if you didn't do that, at least you'd be prepared to explain what that absence was for. So let's keep going, Max. We've got more slides. Just bottom line, team, we are lawyers. We think we should have access to our client. We're going to have to get Congress to change that law, that there is no access to clients officially when they are in secondary inspection.
Lenny, do you want to talk about the right to remain silent? This is the thing, is I really want you to say what the, what the law is. But for me, of course, you don't want clients to make admissions
Right.
and self-incriminate, incriminate themselves. However, they don't speak at all and they're presenting themselves, they're going to be in there even longer. It really depends what it is. And if you're really worried about a client incriminating themselves, if you can control it, they shouldn't have been there in the first place. And I'm talking about returning to the United States from foreign travel. I'm not talking about traveling domestically yet. But if you have real concerns about that, if they don't talk to them at all, the action could be an ER, could be turned around, it will be detention. They're only going to go in what they see in their systems. And if it's something that can be cleared up, then yeah, you want them to talk about it, but you got to know your client and whether they can really articulate this or not.
You absolutely have a Fifth Amendment right to maintain silence in the interior of the United States and in a removal proceeding. But remember, if you're in inspection or you are being charged with inadmissibility, the burden is on you. So your silence, the inference can be then whatever the government is alleging. This is obviously a judgment call, client by client. Alexis and I cannot stress enough that it is a ground of inadmissibility to admit the elements of a crime. So yeah, I did Molly when I was young, when I went to these parties. That's an admission of use of a controlled substance. Or, well, yeah, I didn't really work for that company, but they approved my H1 and then they sent me off to another company. Well, maybe that's okay if you actually understood secondment and subcontracting and was the H petition amended, but the way you're describing it, it sounds like it's fraud. So here, just non-immigrant intent. Another reason people sometimes are refused admission at the border, they have a visa such as an F1 or a B1 where they're coming for a business visit. But at the same time, they can see in the databases that you have been approved for an immigrant visa, maybe an extraordinary ability visa or a labor certification. This is where your client, before they travel, must know how to talk about their own situation. There is a doctrine called dual intent where you can explain my current intention on this particular trip is to fulfill a temporary purpose. Yes, I am being sponsored for permanent residence, but I have not yet accepted that position, or that's so many years into the future. This is what I'm doing now. But the burden again is on you to show that you are entering for the purpose for which your visa is. So, all right, let's go on. Next slide. I think we've done this. I'm just going to keep going, right? National security arrest. These don't happen very often. It's 235C. This is as old as the country. It was originally part of the Alien and Sedition laws. It has really big in the 1950s. In my notes, I gave you in the slide and in the actual notes to the slide, these are old cases. It has been used in extraordinary rendition where we don't even know about it. There was a famous case of a man from Canada who was coming back through the United States on a transit visa. He was extraordinarily rendered to Syria before the Syrian civil war. They held him in a prison for months and months. He tried to sue the US government in civil rights violations later. No. This is possible. Will the Trump administration activate this? They could. And the old law where we did get habeas, where we did have a hearing before an immigration judge and then an appeal to a tribunal, the law was amended after 9/11, and it's really just the Attorney General's discretion. So if you have any clients that you think could be someone entering that they might use this national security argument, maybe someone who's been a very politically active person that the government now perceives as against the United States interest, that person needs to be prepared before they even attempt the travel. Alexis, did you want to talk about this one at all? This is very rare.
Nope.
Okay, let's go on.
I'll deal with it when it happens.
Okay, Canada, aren't they visa exempt? They don't have to register with this new registration requirement. They're cool, right? What do we say to Canadians?
Oh, okay. So Canadians sometimes are the purpose or by accident, I don't even want to say abusers, but they get 6 months on entry. They do not need a visa. Few exceptions like coming on E as investors. And they do get 6 months on entry, but if you come at a land port, they will not be issued an I-94. You have to ask for it and pay for it in advance. And if you do not have an I-94, then you are not considered registered. And then a Canadian who came in a land port who wasn't considered registered, if this alien registration bolstered system comes in on April 11th,
Which
they
is
will
Friday.
yeah, I don't like to think about dates. I believe there'll be a TRO, but that's how I sleep at night. So they'll have to register if they've been here for more than 30 days. And so they're very
It won't have to be fingerprinted though. Other foreign nationals have to be
Yeah.
fingerprinted, but they've made an exception for the Canadian.
So Canadians very much they should, if they come through an airport, they will get an I-94. They're considered registered. They don't have to do this. And one of the famous examples now, that person with the TN, the Canadian who was held by ICE for 3 weeks, frankly could have been Border Patrol, but down in Mexico. Again, it's more complicated than the media made it out to seem. I know her lawyer who got her out of that. She kept trying to present her TN and was told no. And the reason they couldn't let her go is it was way too long. We don't agree with it. And the process didn't run as it should, but it was because there was no place to send her. That is also the situation with the Welsh woman who was coming to what she thought was okay, which was to house swap, or she was coming to do light housekeeping. That is considered work. That's always been considered work. If you came here on ESTA or a Canadian visa waiver and you said, oh, I'm just coming to visit friends, but I'm in exchange for using their place, I'm going to walk their dog. that's considered work. We used to hear about grandmothers coming and they'd say, oh, I'm coming to take care of the newborn baby. You know, on an off day, you might hear, well, you're taking a job away from a US worker. So, you know, people always need to
Even
be
nuns,
careful.
even nuns. There was old
Yes.
cases when we used to actually be able to litigate these cases because they didn't use expedited removal, and you could request in a removal hearing or a deportation, we called it exclusion hearing. We could litigate it. We lost. So what about digital nomads from Canada? Their job is in Canada. They just want to get in the sun in Arizona. What do you think about that?
Well, just getting the sun in Arizona is great, but if they're going to Joshua Tree and they're an influencer and they're going to be doing things from Joshua Tree to as part of their job, maybe not so good. And also what they say at the border, and it's crazy to me and probably to you, Lenny, that matter of Hura is still the standard 1978 about what work is, and it's a tailor. But again, they see a lot of people going to Florida, going to Disneyland. Are you going there with your family? And while you're there, are you going to answer some emails and some texts? Sure. Are you going there to to finish doing your influencer things at Disneyland? Yeah, you're getting paid in Canada, but what you're actually doing here, and what is the benefit, and where are you going to take it? And it's a topic for discussion. It was just a topic for discussion just last Thursday in our CBP meeting with them, because this is the modern world, but the law has not caught up to it.
My friend who was expeditedly removed was on vacation, but did check his email and do a little bit of light editing for his employer. He was paid outside the country, but the employer was a US company. So they considered that to be work. Therefore, they expeditedly removed him for visa fraud in the last time he entered.
Yeah.
Right, I just want to talk about Safe Third Country Agreement. IARC spends, sorry, one back one. IARC spends a lot of time talking about the northern region, and there's a special task force that Amelia and other people in IARC are running. If you are seeing clients who say, should I just go to Canada? You should understand that if they're thinking about asylum, they have to apply inside the United States. There are exceptions if you have close relatives in Canada. Unaccompanied minors are supposed to be an exception, but this is not something to tell anyone to do casually, because what will happen is if Canada pushes them back, they will end up in potential detention with ERO eventually, with ICE, turned over from our border port into ERO and then into detention. Okay, Mexico real quick. TN status with Mexico, but they need visas, unlike Canadians, to get an actual visa stamp. My dog is barking. Alexis, anything else on Mexico?
Yeah, they have to, there's a lot of traffic about this because of the visa adjudications at Mission Mexico, all the U.S. embassies in Mexico. A lot of TNs were getting denied at the window because of what people, including renewals, what people were saying. You know, they're applying under animal husbandry, and then they'd ask at the window, what are you actually doing? And I'm milking cows. So there are harmonization to make it consistent in those standards. But I was also at the Department of State meeting, and they sent consular officers on a field trip, and the legal office too, so they could see that. So to really be prepared at that window, just like they are at ports of entry. And then it is in the law that you could change a TN employer for a Mexican at a port of entry. You have a visa, it's not good for 4 years. You just want to change employers, you bring a new employment letter. Some ports will do it, very few. San Ysidro will, El Paso will, other places will turn you around, say that's not a thing. So really just get very granular information about that.
Just so you guys know, I've had Alexis guest lecture in my advanced business immigration class for an hour and 20 minutes about the complexity of the TN. It's probably not something you're seeing every day. If you aren't familiar with the TN categories and you are representing Mexican nationals or Canadians, you should learn more about it. TVPRA, Trafficking Victims Protection Relief Act, should protect unaccompanied youth at our southwest and our northern border. There is an exception for Mexican youth. They have to show they would suffer extreme trafficking risk or some other humanitarian extreme answer. Otherwise, The last Trump administration, they rejected their obligations under TVPRA, and it took litigation to restore the right of youth to be paroled into the United States and taken into HHS custody. So all of us who work with youth will be watching that, but we might want to be prepared. If families are asking us, can my son or daughter appear at the southwest border and knock at the port and say, please let me in. I can't, I'm in danger at home in my home country. In theory, yes, but what the Trump administration will do, we may need litigation. Okay, Max, next slide.
I mean, we are hearing that they are maybe even already doing it, family detention, so.
Yeah, so this detention slide that I made, I wanted Gemini to make a picture for me, and it would not make a picture when I asked it to put some white people in detention, and every picture it made for me, it was only people of color. What does that tell us about artificial intelligence? Okay, lawful permanent residents, as I already said in that video clip we weren't able to use, Matter of Kayada was a lawful permanent resident, only went for 2 weeks to the DR. Case was fiercely litigated. Case was taken to federal court. Now that Chevron has been overturned, it is possible that if you do have an empathetic, good case of an LPR who is returning from a brief casual trip, who wants to make an argument that the government's interpretation of detention for permanent residents and what is an admission under 101A13, just look out for those cases because maybe the time is to litigate them again. Family detention has reopened at Carnes, and we've heard stories of people being held at ports or at Border Patrol along the northern border and then being relocated to Carnes. We also know the Department of Defense is getting ready to open a big facility. We don't have a CBP detainee locator, Alexis. So what can people do?
Well, the reason is it's not really detention for them. What's happening, if you go behind the door, what is happening is they've encountered someone, say it's an LPR with a, old conviction, and they must call ICE, ERO, and say, well, first they'll talk to headquarters and get all the information. If that person's not caring what that is, the reason that it might be longer there than 48, 72 hours, which is supposed to be the max, these places are not set up to house people. Physically, physical setup is not set up for it. Plus, they don't want to do it, but they're not getting the answer that they need from headquarters. And then once the answer from headquarters is yes, that they need to call ICRO, and they're waiting on ICRO to come pick them up. When it's taking too long, or they just are going to stick their necks out, they're paroling them in. And they are sticking their necks out by paroling them in because they are getting in trouble for doing that.
So that's at our airports or ports
Yeah.
of entry. Max, next slide, where we have ICE being delayed in picking people up from a Border Patrol sector. So that's in part President Trump's expansion of expedited removal, if you've been here less than 2 years, to the entire country. Obviously, that will be litigated again. Always arrest within 100 miles of the north or southwest border has been part of expedited removal since the Bush administration. Transfer to ICE can take time, and local police are sending people to Border Patrol stations. So we don't have, as Alexis is saying, we don't have a detainee locator. People seem to be disappearing. So I've come up with a few ideas, Alexis. I'm just going to share them. This is a professor being wacko. Are you ready? People who don't, their phones are taken away, they are searched on their bodies if they're held. People might want to have a life alert button, like an elderly person that you push the minute you've been taken into custody, and that sends an alert to the company that alerts your person of interest. That could be your attorney, that could be your family member. They know where you are by GPS location. So that could say right away that foreign student that might have been arrested, or that foreign national is arrested in a traffic stop upstate. Maybe we now know where you are. If you do have an ability to send an alert quickly, you could do that. Maybe you want to have the equivalent of an Apple Tag or a Microsoft device sewn into the lining of your shoe, so that people know where you are. Again, you will be strip searched. Your your clothes will be changed when you get into detention, but at least someone will know where you are. What do you think, Alexis? Am I in Mission Impossible territory here?
So I was thinking AirTag, but I just don't know. And when they take what they take from people, like, they're not going to take it immediately in secondary. And listen, clients contact me from secondary all the time. So it really depends on what they're in there for and whether they let them keep their phone or not. But always, if they're nervous about traveling, making sure someone knows, their flight, have the itinerary when they were supposed to come, and that they didn't hear from them. And, you can put that action plan in.
So traveling in the interior, this is completely different. We were not necessarily going to cover that in this webinar. There are areas of the country where CBP and ICE set up checkpoints. So Highway 5 in California, I grew up with that one. In Arizona, I grew up in Arizona, that 100 miles or more along the desert between the southwest border into the United States. The Supreme Court has said there's a diminished expectation of privacy when you're in commercial carriers. So there's case law about being able to ask people for identification on a train or a bus. And we know of cases here in New York where Border Patrol might be stopping people at an Amtrak station and asking everyone for ID. This is where you do have the right to say, am I free to go? Or assert your right to silence. But the consequences of that, in theory, could be arrest. And so as allies of immigrants, I think we all have to assert these rights. If Alexis and I quickly say, I'm a US citizen, here's my passport, let me go, I need to get on the train, I have to go, we're not really helping all the non-immigrants, the non-citizens in our community. So am I going to be brave enough to do it? I might be. I haven't been stopped yet. Alexis, what do you think about domestic travel, getting on a plane, let's say you have TPS or your TPS is pending and you want to fly from New York to California? What do you think?
Yeah, I wish I wasn't going to say that I'm worried about it. Not because TSA is actively doing this, at least not yet. Although, frankly, Doge wants to get rid of TSA, so maybe there won't be TSA, but who knows? But and people definitely should not go to Puerto Rico. Do not
Right.
go to Puerto Rico. I learned this as a young lawyer, where a client who was a long overstay didn't get advanced parole yet and went to Puerto Rico, and because she looked away, she was definitely profiled, was put in removal proceedings, and it freaked me out. And so I've always said it from then on.
Well, I
I,
lost that case. I should
yeah,
say I litigated that case in 1993 on behalf of the Guild. In the First Circuit, we only got one judge who was Puerto Rican to agree with us that there should not be inspections in Puerto Rico.
yeah.
We lost. So it's my fault. Everybody blame me. Nobody goes to Puerto Rico except Puerto
I
Ricans.
say the contiguous 48 states. I don't know where I think the plane going to Alaska or Hawaii is going to go, but that's what I say. But if people are nervous, I mean, I had people in the first few weeks of the Trump administration say, my friend is undocumented, was driving to Vermont from New York. She's worried. Well, the thing is, like in Maine, we have heard about people being pulled over. They have a work visa in there. They're just not familiar with it. They end up in with Border Patrol. They have an NTA for no reason. So if they're really worried about it, it pains me to say it, don't do it. And especially if there's a criminal issue, they could be flagged for other things. Not by TSA necessarily, but if they're at the airport and something has triggered it. So I run of the mill, like our Dreamers and all that are traveling, which so far, Dreamer parole is fine. If it's somebody who has seen VHA who's ending on April 24th, they're in the grace period now. I wouldn't fly again, not because TSA is actively looking at this, but what if they have another reason why they were stopped? Same name as somebody else, and they're just talking to them, and just wrong place, wrong time. So this isn't the time. While we're still in the 100 days of this administration, we haven't hit that benchmark yet. We're not at midterm elections. I would be very cautious.
Okay, next slide is just again reiterating that it is an open question about the right to counsel at a Border Patrol station, you could try to make the argument. Of course, I always begin with sweetness and honey, which would be a polite call to the station and say, I understand my client is there. I do have a G28. Can you give me an ability to get that to you? I would like to talk to you about why this person has a pending application for asylum and doesn't need to be detained and is not a flight risk and is not a national security risk. We all know of examples in New York where people were transferred to Batavia or further away, even though there appears to be no criminal activity and they had pending applications. But it is not clear that when you're in, you were arrested in the interior and it is a customs agent, sorry, a border patrol agent holding you, you're going to argue Section 292, the right to counsel. You're going to argue if an NTA is large, they have the right to counsel. You're going to argue the very old case, Yamataya v. Fisher, 1903, which says once you are in the United States, due process attaches. So I think our problem sometimes is we've had very junior or ill-informed people at Border Patrol stations saying things like, you don't have a right to counsel here. And that's because they don't understand the context. So you want to ask to speak to a supervisor. And Alexis, you gave us where to call again or where to
Yeah.
reach out?
Yeah, I mean, you should call deferred, ask to speak to a supervisor. There's also a separate number for the professional service, manager. Keep calling, keep doing it.
Okay.
And also I really want to address, like, secondary inspection, while you're not free to go, it's not detention. So if an attorney is brought into secondary inspection, including a US citizen, yeah, they can take your phone. You can start privilege. They have to go through a whole another process. You get a receipt for it, it's sealed and all of this. But you are a US citizen, is not going to be brought to detention or ICE to be called to detain you or arrest you. If you're happen to be an attorney who's got your own criminal issues also, long ago, and you're worried about traveling just in general, that's a separate matter. But not solely because you refuse to give them your phone or you asserted client privilege, that you're going to be detained and not let go. Could be there for a while.
I was asked to recite the case name Yamataya, Yamataya v. Fisher, 1903. Oliver Wendell Holmes writing the opinion saying Fifth Amendment applies to all people in the interior. However, that old case said she got due process even though she didn't understand anything that was happening to her. That the more recent case, Landon versus Placencia, 1984, returning lawful permanent residents stopped with allegedly smuggling foreign nationals entitled to greater due process, even though she had been outside the United States. So that would be for an LPR. If you are at those ports of entry or at the airport, you can try to make these arguments, but physically you're really not in the United States in terms of the law. You haven't, the law creates a legal fiction. It's called the legal fiction of the entry doctrine. Okay, Max, I know we only have a few more minutes.
Lenny, do you wanna, I think it's important
our
for
next slide?
people who are in the advocacy and especially what's going on with political speech.
Yeah. Should we talk
And
about
if you
that?
have
Yeah,
you have advice for that.
I do. So first of all, we're hearing a lot, and this is just very distressing about student visas and student status. And AILA has a lot of resources on this. National Association of Foreign Student Advisors also putting out information. Mr. Rubio, our Secretary of State, making some statements that are really troubling about 300 plus terminations of visas or revocations. So a State Department can revoke a visa if the government believes it is in the national interest. They can also revoke visas for other reasons. So it has been long the practice for have something called a prudential revocation, where they get information that you were stopped for a DUI, or driving under the influence for drugs, or a battery or an assault, and a student will receive a letter or notice that the consulate in London has revoked their visa. But a visa is a travel document. So what about your status? who controls status for students is not USCIS, but ICE. And that's because of the events of 9/11, where many of the attackers were foreign students. So ICE has this electronic registration system, and people are waking up to an email from their designated school official or checking into CBIS themselves and seeing that their status has been terminated. So the question is the government following its own regulations? CBIS has things it can do in its database screens that I believe are ultra vires or outside the scope of their regulations. So it's going to be a case by case choice for those foreign students who've been notified that they are out of status and for their school. In states where you can attend school without an F1 designation or an approved I-20 or status, you're an undocumented person now, you could finish out the semester. If you do not acquire 180 days of unlawful presence, and we can argue about when that began, you depart the country then, you don't necessarily have a barrier to reapplying for some other future visa. However, there's a ground of removability for being a student visa abuser. And I found some old cases where a student continued to attend school once they'd been terminated for other reasons, like their school went bankrupt. And the government did put those people into removal proceedings, did deny adjustment of status, did try to argue they were an abuser. They won in the 10th Circuit, not a very liberal circuit. So let's not be cavalier. Let's not rush to assumptions. This takes careful legal analysis of visa and status. Now about speech. There has never been a Supreme Court case that held a foreign national has the same rights to First Amendment freedoms that citizens and permanent residents do. There have been some lower court cases. However, some of the old immigration cases, like the US v. Turner in 1903, saying that an anarchist could not give a speech, or the cases of the communists who were not violent but committed to worker rights. The Supreme Court said you don't have a right to have political activity or the right of engagement. Those cases all predate Dennis v. United States, a case which held that for US citizens, mere speech is insufficient to allow the government to punish you. So if you do have a foreign national who you believe is being targeted for an NTA for termination of a visa, Alina Das of NYU, part of our Immigrant Arc Defense Roundtable and the larger New York Roundtable, does have templates for potential habeas and other APA challenges to that revocation of status based on targeting for selected speech. That said, I was part of litigation years and years ago as an amici. Mark Vanderhout was the lead counsel. He's amazing. He's now involved in Mr. Khalil's case. This was the Palestinian aid at UCLA. We argued selective prosecution. We tried to enjoin the NTAs, the beginning of the process, in those days called an order to show cause. We lost at the Supreme Court with Scalia saying selective prosecution is a very rare bird, rara avis, and also it's not clear that foreign nationals have the same First Amendment rights. That's the case on the books, Arab American Discrimination Committee. There's the laws moved and there's better cases, but court stripping happened in 1996. So the first motion oil is going to file or the US attorneys are going to file in response to anything you file in federal court, you better be ready for the motion to dismiss for a lack of subject matter jurisdiction and take a look at 242G. Okay, last thoughts. Next slide, Max.
Okay, we are at time, so
Yeah.
we gotta.
If there's anything else we want to do.
Yeah.
Remedies for students, we'll skip over it. It's a very advanced topic. Q&A and hypos, we tried to answer all the questions. Can you just show me the list again? See if there's anything, Alexis, you want to pick out of this list that we didn't touch?
I think we touched a lot of it. What I would really say, and I really would urge you to find, you're in this group, so you found your people. I'd find more people. Really what ALA is great at, both you join a local chapter, depending on where your you're licensed out of. I have all this information because don't be me, but I have like 40 listservs constant. And as Lenny mentioned, the liaison minutes, which we just still had all these meetings with the government. You can get involved with local liaison. You can really rely on each other. And this is what we're all telling each other. Rely on each other for this information. We also put in, trends that we're following. We really separate what's fact from rumor. And it's everyone like yourselves that are on the ground who tell us all this. And as Lenny mentioned, nonprofit members, there is a significant reduction in dues. And so I would urge you, we're growing, we're continuing to grow. We're almost 18,000 lawyers strong, and we're doing so many things in this space, including litigation. And this is the way we got through it the last time and the way we really need to get through it today. So I really appreciate you listening to this. It's a lot of information, and there's probably 6 different things that happen while we're talking. And to try to stay on it as much as you can, but also take a breath, not internalize everything that's going on with our clients. That's already something you have to do in your practices, and you hear trauma and the experiences with everyone. But really what we're telling each other, because we can't help everybody or anyone if we're just all really take it so much internal that it feels not doable. There are tools, there's ways to get every single one of these things. And I do believe the tide will turn. I don't know when, but it will turn.
Alexis, thank you so much for doing this. Immigrant Arc and Max Wellington, thank you for hosting. I know that people would like more information about privacy on their phones, and I think Immigrant Arc has resources on that already through our listserv and through our Signal group. And I will let Max, I'll be sure and send him what I have so he can send it out to those groups.
Yeah, we will be sharing more information, and the slides and recording will be shared once the recording is ready out to the list of registrants. So if you are listening to this, you will receive it, and we will also be posting the recording probably with the slides attached to it up on our YouTube in some capacity and posted to social media. So thank you everyone for coming. We peaked at about 300 live participants. So thank you so much. We're very excited. We put this together very quickly, and I think Lenny and Alexis did an excellent job. Thank you so much for coming. I hope
Thanks, Max.
everyone
Send out the
got something
client
out of it.
flyer about electronic searches with the materials that I sent. I
Yes.
think that would be really helpful.
Okay,
Yeah, we will.
goodbye, everybody. We'll see you again in the future.
Bye.
Bye.